Hello everyone, today I'll be sharing another legal story with you. So what happened on 31st August 2025 is that the Delhi High Court was dealing with the case of MS Archana versus the Union of India. So in this case what happened was that the Union Public Service Commission, they issued a notification in 2023 for the recruitment of post in the armed forces. Okay, so notification regarding recruitment in armed forces was issued and there were total 92 vacancies that were notified, okay, including 2 for the female candidates. So there were 92 vacancies that were notified, and out of this 92, the 2 vacancies that were reserved for especially for the female candidates. Okay, the 2 vacancies that reserved for female candidates were filled, and out of 90 vacancies 70 were filled by the male candidates. So out these 2 were filled by the female candidates, okay, and out of this 90, 70 were filled by the male candidates, okay, and these 20 seats, they remain unfilled and they remained vacant, okay. So these 20 were unfilled and vacant. The petitioner contended that she was 7th in the merit list after the 2 candidates who had been appointed against the reserved vacancies, right? So she was 7th in the merit list after these 2 candidates that were appointed for the appointed in the reserved seats. Okay, in these 2 reserved seats they were appointed, she was 70th after she was 7th after them, okay. The petitioner contended that despite these 2 vacancies which remained vacant and not reserved for female candidates, she was not offered appointment. She contended that since these 20 seats, they remained unfilled and vacant, right, they were not reserved, right, these 20 seats were not reserved for anyone, and despite that these seats were not reserved and they remained vacant and unfilled, she was not given up or given an offer for appointment, right. This was basically she is aggrieved for, right. And while disposing the matter, the Delhi High Court said that there were total 90 vacancies, okay. So there were total 90 vacancies because 2 were reserved for the female candidates, okay, and these 90 vacancies, they were not reserved for a male candidates or a female candidates, and they were open to female as well as male candidates. So these 90 seats, they were open for all because they were not reserved, okay. So the court concluded that the petitioner has a fit to fly certificate, right. She has a fit to fly certificate, and also she cleared all the rounds of examination, right. Therefore she is eligible for appointment. Why? Because these 90 seats, they were not reserved for anyone, okay, and since these 20 seats were vacant, okay, and they are not reserved for any male or a female candidate, as they were open for both male and female candidates. Second, she has a fit to fly certificate and she has cleared all the rounds of examination, therefore she is eligible for the appointment, okay. In this case, basically the Delhi High Court relied on the case of Ashnur Kaur versus Union of India. So basically they relied on the Supreme Court judgment of Ashnur Kaur, and they observed that it is not permissible for anyone, ठीक है, it is not allowed or permissible for anyone to interpret or administer any stipulation, notification, okay, or advertisement in a manner which would be gender skewed. So it is not allowed to interpret or administer any notification in a gender skewed manner. Gender skewed means basically when there is a imbalance in the strength of male and female because of the gender biasness. So the interpretation should not be made in a manner that it is gender skewed, okay. This is what was held in this case. Thank you so much.